Okay, so it's well established that directors are not entitled to company money. It's well established that if a director does receive company money, that they have to justify receipt of that, and if they don't, then they can be ordered by the court to repay it back. And the basic principle is that once the liquidator, if the liquidator is making the application to the court to correct the situation for the benefit of creditors, once the liquidator has proven that a particular director has received company property, money, whatever it might be, that if the director is unable to justify their receipt, then basically they can be ordered to repay it, and the burden of proof actually flips from the liquidator to the director in relation to the justification. So the liquidators just have to prove that the directors received the property. They don't have to prove anything besides that. It then becomes the director's duty to show and prove that it was something that was happened in good faith. It's not that the director can simply sit there and say the liquidator has to prove that it was received in bad faith. Now, what often happens is particularly there is this assumption that a lot of directors perhaps maybe get away with stuff, but the simple fact of the matter is it does not always the case. And so I'm going to draw your attention to the case of Snelling House, in which the late Gabriel Moss QC was the judge in this particular case, and I'm going to read out the postscript. And this was a case when a de facto director had been disqualified, and where that particular director had also allegations of essentially dishonesty in relation to their conduct. The postscript is as follows. I would note that this case shows how easy it is for a de facto director. De facto director is somebody who holds themselves out as a director as opposed to being registered at Companies House. So how easy it is for a de facto director who is a convicted criminal to fob off a pressing creditor and loot his company of money needed to pay creditors. The fact that he is given a disqualification undertaking is little comfort to the company's creditors or the public, while the director enjoys his ill-gotten gains in Spain. Unless the respondents pay all the monies which I award against them, I propose, subject to any further argument, to direct the liquidators to refer the papers to the prosecuting authorities, and also to inquire as to what checks were made by the bankers and accountants, in this case into R2's background, before they dealt with him, and in particular whether they were or became aware of his convictions or his conviction for dishonesty and his disqualification. So you can see there a judge taking a very robust line in relation to director conduct. Questions, queries, concern, give us a shout. We know insolvency inside out.